I think if you consented, but again, how's he going to prove your consent? If you email him and he emails it to you, you can say, sure, I accept service via email and you're all good. But the phone call saying leave it under the mat.
Leave it under the mat. I don't know. I got to go find it and get the copy of the thing. And we got it.
Although I thought we read a case in law school that was like, you have to like place it in their hands, which, if someone's clearly trying to avoid service,
hands behind my hair,
just throw it at you and be like, aha, gotcha.
Yeah, no,
I know you got
they can throw it at you. They can drop it at your feet, throw it at your feet, all that kind of stuff. So, that's how they, that's how they do it. So, interesting question on service. Now that we've recorded the podcast and we're going to release this, this can just be my official waiver of service, right? Like, constable, if you're out there, if I ever challenge service later, this is let this recording constitute my waiver of service, and I'm going to answer the lawsuit. All right. Welcome to episode 121 of the Weekly Docket, a podcast by the Silberman Law Firm where we talk legal news and practical law. Today is May 8th, 2026. I'm Phil Silberman, owner of the firm and your host, and I'm joined by Chris Field, who's the firm's supervising attorney. Chris, how are you doing?
I'm doing all right. Good. It's a rainy day.
That happens sometimes. All right, let's just jump right into it. Give me another short show, kind of a product of how busy I am doing other sort of things at the firm, but we got to deliver for the listeners. But short show. Let's get into the first question. Can I represent myself using AI in court? The answer, yes, you can. As long as you're sued as an individual. Now, Chris, if the problem is, or whether plaintiff or defense, I shouldn't say whether you've been sued. The problem we get a lot is they're attempting to represent the LLC or the corporation. Can they do that?
No, maybe in JP court, but not anywhere else. But I don't even know about JP.
Yeah, they get sued, and usually it's county or district court, and then they call us because they've attempted to file an answer for their LLC or their corporation, and then the opposing counsel tries to strike their pleadings, and the judge is usually nice and says, "Hey, you've got 30 days to go get an attorney." So,
I saw something where somebody tried to like have an AI generated attorney. And, we still use Zoom for a lot of stuff. I don't think it was in Texas, but I think someone like actually put on like an AI generated video and like, yes, this is my attorney, and pressed play. And the person, obviously looked like AI, and the judge caught it very quickly, but was like, "Hi, I'm so-and-so. And on behalf of client name, I must address the grievous allegations been made today before this court." And then judge is like, "What is this? Like, is this your attorney?" Maybe that video was fake too. I don't know. I take everything as, with disbelief in my world.
It is hard to figure out what's real and what's not real. And it doesn't shock me that could happen where you have the AI avatar. I thought about using an AI avatar for training people and that way I don't actually have to do it, but we held off on that project for the time being. But here's kind of a tangent or a side question to that, and I had to look it up. Is it potentially the unauthorized practice of law for someone to represent their LLC? I thought about it.
Yeah, I think that's the problem. I think that's why you can't do it. It's the same as like if you're the executor of an estate, you have to have an attorney unless you're the only beneficiary. Otherwise, you're a fiduciary for the estate and for the other beneficiaries. So you must have counsel advising you. Otherwise, you're effectively engaging in the unauthorized practice of law.
I looked it up, and this was under the penal code. Now, there are different standards for the unauthorized practice of law, I believe, but at least strictly talking about the penal code in Texas, it has to be to obtain an economic benefit. Because I thought about this the other day because I had a potential client call up and he used AI to represent his brother who owned a rental property and was getting foreclosed on, and he actually managed to get the judge to grant the TRO to stop the foreclosure using some of the AI documents. And the question is, what I'm surprised the judge even entertained it because he obviously wasn't a lawyer. Was he committing the unauthorized practice of law? And was it for any kind of economic benefit? And if it wasn't, at the very least, I guess it's not a penal code violation, not criminal, which is a class A misdemeanor. If you get caught the second time, I think it's a third-degree felony. But I don't know if it certainly, as far as the state bar is concerned, you can't do it. I think as far as the courts are concerned, I think you can't do it. But people are getting, pretty bold with AI now. So.
And they don't like us anyway. They're like, why would I want to go spend thousands of dollars on a lawyer when I can just have Claude do it
There's
for
a
me?
lot of, there's a lot of that going around. And I'm, as you know, Chris, I'm a big fan of AI and using it in the practice and being more efficient. But I do believe there's a long-term place for lawyers. It's just going to be the higher level thinking. The AI as a tool is kind of my base case for where this goes. I don't know that I ever foresee the robot in the courtroom, making the argument to the jury. So that's where I am on the position right now. So, well, and if you are sued as an individual, it's certainly fine. You can represent yourself. There's nothing that prohibits you from representing yourself individually. It's going to be a little bit of a DIY project and do it yourself project. And I think the hardest part is if you're in the higher level courts, it's not a JP court where you're just up there telling your story and narrative and the judge is just listening. If you're in a county or district court, there's going to be some formality. There's going to be rules of evidence. There's going to be motions that you need to file correctly. And the courts tend to have very little patience for that. They tend not to like pro se parties. Have you ever gone up against a pro se party?
Yeah, I mean, you say that, and I think the courts say that, oh, I'm going to hold you to the same standard, and then they don't. So I don't want to go too far on a rant with that.
Oh,
one.
okay. So
I was just thinking exactly what you were saying. I think if they're going to do that, it really should be the same standard. If I'm going to hold myself out as a car mechanic, and I don't know how to fix a car, people are going to have very low tolerance for that. If I hold myself out as a plumber and I can't fix a sink, if I understand people want to be able to defend themselves, but if you don't know the rules and you make missteps, there should be some consequences for that, because it is a drain on the system to have pro se litigants. And now they're all going to think they're cute and they can use AI, and AI is going to say this, and they're going to want to read what the AI spit out for them to read to the court. Doesn't sound.
I'm sensing you've had the experience for courts have been a little bit more lenient and given a bit more grace to pro se parties, which
they almost do. They say they don't. They say, I'm going to hold you to the same standard. And maybe they'll say, all right, sir, you need to wrap this up. But they really do seem to bend over backwards for these pro se litigants, and it's frustrating a lot of the time.
Okay, well, let's move on to our next question. Okay, what do I do with the will after my mom dies and I'm the executor? We had this come up. I think a lot of times they just want to go down to the county clerk's office and deposit the will with the county clerk, and I don't. You would say that's probably not a good idea.
Definitely not.
We had one of the probate attorneys at the firm sort of flesh this out a little bit and tell me if you agree, disagree. It sounds good to me. If they do that, the county clerk will accept it. But apparently what's going on at many of these county clerks is they'll open up a temporary file, and
I don't think they will accept it. Maybe they will.
Yeah,
Tell me
well,
what you've
this is
experienced.
this is from Ashley at the firm. Okay, she says if you go down there and deposit it, and there's no application, because if you're going to probate the will, you'll file an application and there'll be a case number open up. They said you just go and deposit it. They open up some sort of temporary file, and then if you go and file the application after the fact, it's not like they'll just do the reasonable thing because they're the government. They won't just, match the will to your application case number. They'll make you or the client go down there and like physically take the will back out. Like the clerk's there. Here's the will. And then you're like, okay, now here's it back. Will you deposit it on the cause number with the application? I mean, does that sound
Right.
crazy? That's what
No, but that's what happens. I think, I guess we're crossing wires. I don't think you can go deposit a will after somebody dies. I don't think they want it. If you want to go deposit your will with the Harris County clerk right now, you may. You may go down to the 201 Caroline, 8th floor, and say, I would like to deposit my will with your office. And they will open a will deposit case and give you a case number. And they will say, all right, here's your ticket. We now have your will in our possession. And if you have appointed your wife as executor, but you die in Massachusetts, your wife can't call them and say, okay, well, I've hired an attorney in Texas and I want to have my husband's will added to the probate file. They're going to say, no, you need to come down here. You need to get the will physically, and then you need to, file it into the probate case. So they will release it to the executor. I would just be surprised if they would accept a will from somebody who's not the testator after they died, but maybe they will. And maybe we're different.
I tend to think, they should, because I thought there's a law that says, if you're in possession of a will after someone has died, you're obligated to deposit it with the county clerk.
That's a very good point. You're spot on with that.
So I don't know. They if you're in a situation, you're in possession of the will, I think you're supposed to go deposit it, but we can double check that. But this was more of an administrative thing. So what we want the clients to do is hold on to the will, let us file the application, and then go down there and deposit it after we file the application. So they'll match it to the case number. So,
yeah, you're exactly right. Because a lot of times, they'll call us and they'll say, my sister has it. And so when we send that letter to the sister, you're right. I can't demand the sister give me the will. I can offer to take it, and I can say, hey, your brother wants to probate the will. You can send it to our office if you like, but pursuant to a state's code section, you are obligated to deposit it with the county clerk of the county that would have probate jurisdiction. So you're spot on with that. So that they don't have to give it to Silverman Law Firm. They don't have to give it to their brother. They can say, hey, I don't want to probate this, but I also don't want to be in violation of the rules. So here you go. If my brother wants to probate it, I guess that's on him.
All right, let's move on to our next question. What is a motion to retain, and when do you use one? So,
when you haven't done anything on your case in a long time, and the court wants to DWOP you, and you say, no, I'll do something. I'll work on it.
So DWOP is for lazy lawyers, right? So your case has been filed, you haven't diligently tried to serve, I guess, or haven't moved the case along, or the case is just sat the court and says, hey, I imagine all the judge what's the head judge? There's usually in a district court, there'll be some judge that's kind of in charge of the other judges. I don't know what that's called, but the judges have a meeting and they go over how many cases on their docket, and they're like, court number so-and-so, you really have a docket, that's kind of the number here has exploded. We need you to really do something on that because it's looking really bad. And, we're going to need you to get that whittled down. Chris, you wouldn't know anything about something like that, would you?
I'm not going to say it hasn't happened. The courts are getting more aggressive, though, quite honestly. You file a case, they're like, you better get this person served. If they don't answer, you better get a default on file real quick. And so, we are having to file motions to retain more frequently just to say, hey, we filed this, or we're trying to serve the person, or we filed for default. We just haven't had the default hearing yet. And so if my DWOP date comes before my default date, I want to make sure they don't DWOP my case before I go for a default hearing next week. So I have to file my motion to retain, because that's what they want to see. They want to make sure, okay, you've got a motion to retain on file. You have done everything. You have filed for default, and you've got a setting on your motion for default next week. Okay. We'll retain your case and you can come on down.
Yeah. And DWOP stands for Dismissal for Want of Prosecution. That's all that is. So if you don't do anything, the court will, sua sponte, give you a notice for dismissal for want of prosecution. And then you need to file a motion to retain, go back to the court. Because court, please believe me, court, I'm really here. I'm going to diligently work on this case. Please don't dismiss it. And it's dangerous, because if you get dismissed, DWOP'd, and your limitations period is run, if you go to refile, your new date is the date of the refiling, and you may have taken too long. So you don't want to get DWOP. File the motion to retain. Say, court, I'm here. I'm going to work, and we're going to do something. All right. Next question. Final question. Chris, I'm a business owner. I own the firm. I own another real estate company. I've owned other businesses. You get sued when you own businesses. Okay. It's not fun. I've got a little thing here. My wife was I work from home mostly, and my wife was just kind of out here. She's like, Phil, what is this on the door? Right. And it's I don't know. It's some kind of, it's like a nice little note from the constable or the sheriff. No, the constable. I was like, I was trying to serve you. Right. And if you don't get sued all the time, you're probably like in a panic about it. If you're like me, I'm just like, oh, honey, put that in on my desk. I'll deal with it in a little bit. So, here's not that there's anything terribly interesting about getting sued when you own businesses. It's just part of doing business. This is some crazy tenant. I looked it up who, alleged mold or something like that. And wants to sue the management company that I own, which we're not going to get into that. That's not proper. But here's something interesting. So I called up the constable, and I'm like, hey, you can see, I don't know what you were thinking. You walked up right to my door. My office is in the front of the house. You can see me working here. You just like stuck it on the door instead of, but all right. And he's like, oh yeah, I'm already back out to these constables are not real diligent when it comes to service. So I said, look, come back out. No, I'm back at the station. I can't come back out there now. All right. Well, I'm here, next week, come out. And well, can I just leave it under your mat? Sure. Do that if you want. My question to you, Chris, is that proper service? Would that service be proper if he just leaves it under my mat?
I don't know. I don't think so. What's he going to write on the return? I really wonder what he's going to write on the return.
Not. You need to have it's personal service. Okay. So if you're going to do things like leave it on the door, leave it on the mat, you have to have a motion for substituted service. All right. But look, I told the guy, I was like, look, you want to serve me, come serve me. I'm here. If not, I'm just going to answer the lawsuit. It's going to make your service moot. So whatever you want to do.
Yeah, he could, I think if you consented, but again, how's he going to prove your consent? If you email him and he emails it to you, you can say, sure, I accept service via email, and you're all good. But the phone call saying leave it under the mat.
Leave it under the mat. I don't know. I got to go find it and get the copy of the thing. And we got it.
Although I thought we read a case in law school that was like, you have to like place it in their hands, which, if someone's clearly trying to avoid service,
hands behind my hair,
just throw it at you and be like, aha, gotcha.
Yeah, no,
I know you got
they can throw it at you. They can drop it at your feet, throw it at your feet, all that kind of stuff. So, that's how they, that's how they do it. So, interesting question on service. Now that we've recorded the podcast and we're going to release this, this can just be my official waiver of service, right? Like,
Yeah, that was
Constable,
gotcha.
if you're out there, or if I ever challenge service later, this is let this recording constitute my waiver of service, and I'm going to answer the lawsuit. All right, I'm pretty comfortable with that.
It's an answer on file. You don't
Oh
like it.
no,
The plaintiff
it's
something right now. The plaintiff
it's
calendars
a
your deadline.
$7,800 case. So it's, at some point it might be cheaper for me just to take the default. They don't, I don't think they know that I'm an attorney and we have this law firm because they're suing a management company. And then some of these attorneys a couple of them have sued us and they get like this huge playbook back and they're like, oh no, what did I get into? So, well, good. They should know better anyway. All right, we gotta bring this show to a close. You've got a meeting to get to. I've got to do more data mining. I've been your host, Phil Silverman. Chris Hill has been my co-host today. Like us, follow us, review us wherever you get your podcast. And as a reminder, nothing in this show is to be considered legal advice, and this has all been for entertainment purposes only. If you have a legal question, email us at info@syllablelawfirm.com and tell us you want it publicly answered in the podcast. Everybody have a great weekend.